Morning.
Good morning.
Well, we always do these on the record, so let's go on the record on DC 21-14413, Badali versus Smith and Newman. Council, make your appearances.
Your Honor, this is Kyle Fermenti. I'm joined by Mr. Kip Petroff on behalf of the petitioners.
Good morning, Your Honor. David O'Quinn for Smith and Nephew, Inc. And with me is our Texas counsel, Mr. Brian Johnson.
So let me first ask, we typically put these on YouTube pursuant to the instructions of the Office of Court Administration, but if there's something highly sensitive that you don't want to have on YouTube, I'm happy to take it off.
Not from the defense, Your Honor.
None from plaintiffs, Your Honor.
Okay. I've read the petition, so let's proceed.
Your Honor, again, this is Kyle Fermenti. A little background on this 202 petition. The petitioners, Mr. and Mrs. Badali, they're getting ready to file a lawsuit soon, and they need to investigate potential claims or parties to the suit. Mr. Badali received a metal-on-metal total hip implant in 2011. It is going to need to be revised soon, so it'll be about 10 years and 6 months since he received the implant. Mr. Badali is going to file a products liability suit against Smith and Nephew, Inc., a U.S. corporation that manufactured the parts, and some sales representatives who promoted the combination of parts to his surgeon, a Dallas surgeon. And what we're trying to find out is whether two other Smith and Nephew corporate entities, both based in the United Kingdom, are proper parties to this case in Texas. Those two entities are Smith and Nephew PLC, which is I think the parent company of all Smith and Nephew entities, and Smith and Nephew Orthopedics Limited, which is a UK company that was bought and actually we think is the main designer of these metal-on-metal parts. The question before the court is simply whether the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. That's Texas Rule of Civil Procedure 202.4. And really what we're trying to find out, and we've in our verified petition, we listed out the topics. There are 6 topics. They're mostly very narrow. 3 or 4 of them involve finding out, okay, there's these Smith and Nephew employees, either in the US or the UK. Who did they work for? Why were they listed on as a director for this UK Smith and Nephew entity when they're a Smith and Nephew US marketing employee? Then an additional question focused on Smith and Nephew's chief medical officer, who he worked for in Smith and Nephew. Was it Smith and Nephew Inc.? Was it a foreign company? Was he the true CMO for other entities, and we're just trying to find out who he was CMO for in general on a lot of these. This is a big company. Smith and Nephew is a multi-billion-dollar company. They market products worldwide. They've been marketing products, I think they're over 100 years old, the whole company. The broadest topic is topic A, and topic A just seeks to find out what role, if any, that Smith and Nephew PLC and Smith and Nephew Orthopedics Limited and or any other Smith and Nephew corporate entity had in designing, manufacturing, studying, marketing, and selling the device components, which is the parts implanted in Mr. Badali, in the United States and Texas during the years 2006 to 2011. We have some idea about these companies, but we know that these companies are going to contest jurisdiction in Texas as to them. They're going to say there weren't minimum contacts, they weren't involved, and Smith and Nephew Inc. has already taken the position that they are the proper entity here. I don't think there's a dispute that Smith and Nephew Inc. is a proper party to this lawsuit. What there is a dispute about is whether Orthopedics Limited and PLC are additional tortfeasors who might be subject to liability for independent torts involved in marketing this combination of parts to U.S. surgeons. I think briefly, Your Honor, the Smith and Nephew Inc. did file a motion for protection. I don't know if that's on the docket today, but it involves the same issues. But between the 202 petition and the motion for protection, the important thing for the court to keep in mind is there is no evidence on the record with the court showing any sort of undue burden, undue burden or expense for the court to use in its weighing mechanism under 202.4. Smith & Nephew's motion for protection makes a lot of claims about how much discovery there's been in other cases not involving Mr. and Mrs. Badali, and how much they've had to produce and how burdensome these topics are. But there's no affidavit from anyone saying preparing for these topics is going to cost X amount, or it's going to take X amount of hours. All that the court has really is a petition from another lawsuit not involving these petitioners and petitioner's verified petition. And based on that evidence, there's not enough evidence for the court to make, I think, a finding that the benefit is outweighed by the burden or expense. If the court has any questions, I'm happy to answer them.
Response?
Thank you, Your Honor. Let me give you some context, if I may, about why we're opposing this. Plaintiff's counsel has been involved in 17 cases already involving these metal-on-metal hip implants. We started litigating with Mr. Petrov's firm, I think 4 or 5 years ago. The litigations have been intense. They have served more than 316 interrogatories, 8,600 requests for production, 2,400 requests for admissions. Smith & Nephew, Inc. has produced over 3.8 million pages of documents. Mr. Petrov's firm has taken 120 depositions and counting. They have exhaustively discovered the design of these implants, the marketing of the implants, the post-market surveillance of the implants, everything conceivable about these implants. We've been litigating it intensely for 2 or 3 years. Their firm is also counsel of record in a multi-district litigation in Baltimore. That litigation involves the same implants. There's been scores of depositions taken in those cases and millions of pages of documents produced. They know the relationship of SNN Ortho, one of the UK entities, and SNN PLC, the second UK entity. They've already sued them. They filed a 46-page, 135-page complaint detailing the allegations against these UK entities. They know who they are. They've got the information on how these implants were developed, produced, manufactured, designed. They've taken the depositions of important UK people that were produced in other litigations, including the global product manager in the UK, multiple depositions of the complaint handling people in the UK, the manufacturing director in the UK who oversaw how these components were manufactured. So our position, Your Honor, is why? Why do we now have to produce a witness? And there is no affidavit, but we're going to have to find a person or people, track down the information and give it to them when they already have millions of pages, hundreds of depositions, etc. And in this regard, Your Honor, why do they even need to bring these entities in? As Mr. Formente just acknowledged, Smith & Nephew, Inc. is a $1 billion company. I think the market cap is $40 billion or whatever it is. There's no question as to our solvency. There's no question as to our liability. If they prove it. What I'm saying is there's no empty chair. It didn't come out right, but there's no empty chair. We're not saying, oh, it's not us, it's them. We're not saying that. We've never said that.
Can I ask, wait, can I ask a question?
Sure.
So these other lawsuits that have occurred, are they in Texas or other states?
Some are in Texas, some are in New Mexico. We had 2 in Oregon that we've resolved. There are 2 in California. So they've been in various states. The bulk of them have been in Texas, I guess maybe 6 or 7, but they have cases outside for this firm. And then the MDL cases, you know how MDLs work, they've been filed all over the United States and they were sent to Baltimore for pretrial consolidation. So Your Honor, I guess we're kind of scratching our head saying, first of all, why do you need to bring these entities in? And what kind of discovery is going to result from new entities in?
Mr.
And number
Quinn,
2,
Mr. Quinn, let me ask you this. In other cases, have you designated these other corporate entities as responsible third parties in the Texas cases?
No, sir, we've not attempted to shift liability to the other third parties. These components, they came from various sources, but the core story, and they know it well, it's in their pleadings, it's in the pleading I attached to my motion. These components and this technology was developed in the UK by a guy named Derek McMinn, and he had his own company. One of the Smith & Nephew entities bought that, and that company was folded into Smith & Nephew Orthopedics Limited, a UK entity. That entity manufactured some of the components. They did the post-market surveillance, but the components were distributed in the United States by Smith & Nephew Inc. We did the marketing here. We had the interactions with surgeons, that kind of thing. So they know the whole story. And Smith & Nephew is legally responsible as a manufacturer and the developer, meaning we are the proper party defendant. We've never tried to play a shell game where, oh no, that's them, not us. We've never tried to say that there was a necessary or an indispensable party. We've defended the 17 suits that they filed and I think it's approximately 1,000 suits in the MDL. As if you can prove it, we will pay you. So there's no need to even bring these entities in. And we are concerned about the volume of discovery. I mean, they've got massive discovery.
I get it. Why do you need to do this? It sounds like you already know.
Is that a question for me, Your Honor?
Yes.
Your Honor, I think to clarify, PLC and Orthopedic Limited have only been named in one case. That case is in federal court, and we haven't done any jurisdictional discovery, and we know they're going to contend jurisdiction. For Mr. and Mrs. Badali, there's a concern that we won't have any evidence beyond what we suspect for months before we can actually get to addressing it, because we anticipate a removal.
Why do you, I used to actually do HIPAA litigation, so I'm pretty familiar, not against this company, but I've done this and I'm pretty familiar with this. Why do you even need to do any of this? You haven't done it in the other cases. Why do you need to do it in this case?
It's something that as you work on these cases, we've developed more and more knowledge about them, and it's been a recent, I think, decision from the firm, because a lot of these cases we've been working on have been pending for 3 or 4 years. Mr. Badali, their new clients, that case where we named PLC and Orthopedics, which is we're going to have a jurisdictional fight. I anticipate that was filed a year ago, but it's been in federal court for 10 months pending a motion to remand. So we really haven't had a chance to find out about these companies, and I think it's important to clarify that the question of Smith & Nephew Inc. being a proper party does not preclude these other defendants from being a proper party. Smith & Nephew Inc. shouldn't be able to martyr itself for these entities if they committed any tortious acts in Texas. And instead of having to deal with jurisdictional issues in 3 or 4 months when Mr. and Mrs. Badali file it, we'd rather get some evidence now to let us know conclusively, okay, PLC, they might be on some documents, they might.
All right, so let me ask Mr. O'Quinn. So he's asking very specific things in this case involving, what's in his 202 petition. Have those particular facts that he's requesting or particular areas of inquiry he's asking, have they been developed in other cases? Because he's saying that this really hasn't come up in the other cases.
Well, okay, Your Honor, if you look at their verified petition, number C, D, and E, ask us to identify Dr. Wyman, whether he was an employee of Smith & Nephew Inc., whether he was the chief medical officer for Smith & Nephew Inc. They've already deposed Dr. Wyman, and he testified that he was the chief medical officer. There's documentation where he signed as chief medical officer for some of the post-market surveillance on some of these products. He was employed by a Smith & Nephew affiliate based in Switzerland. He testified to all that. So I don't even know why we need to put up a guy on that. If you look at number A, it's very broad. Identify the role that Smith & Nephew PLC, Smith & Nephew Orthopedics Limited, and or any other Smith & Nephew corporate entity other than Smith & Nephew Inc. had in designing, manufacturing, studying, marketing, and selling the device components in the United States and Texas during the years 2006 to 2011. That's what we've been doing for the last 4 years. They've conducted exhaustive discovery on the design, the manufacturer, the post-market surveillance, the marketing and selling. We've had trial dates. We would already had trials if it wasn't for COVID. We've got trials in February in Texas, in Beaumont and Dallas County, and another court in your court, Your Honor. So that's what we've already been doing. The idea that, oh, we don't know. Well, they do know. I mean, if Ortho was involved, they have documents that show it. They've deposed the global product manager, situated in the UK. I'd also like to respond, Your Honor. You know, Mr. Formente says, well, we're concerned about delay. You know, we sued these guys in federal court, and this is the first time we've sued them. I don't know why they have to sue them 5 years into this, but we've sued them. And we're worried that, you know, we won't have an opportunity to do discovery early when they contest jurisdiction. Well, then just don't sue them. I mean, the delay is because of their tactical choice, for whatever reason, to bring in these entities that aren't necessary to resolve this case, one way or the other. Win or lose, we have a party here. They've got all the evidence they need to put on their case. So I don't understand it. And if their reason is, well, we're concerned about delay when and if these parties contest jurisdiction, that's their tactical decision.
I mean, I do think they have the right to bring in the parties if they're proper parties, though. And I don't know that they are. They are or they aren't. I can see some argument that if this guy was originally employed when he designed the hip implants and with another entity, that maybe that entity would be on the hook, possibly. I mean, I do see that as a possibility. But Mr. Formente, what is it that you haven't gotten in other cases that you need in this case? It's because it sounds like you already know a lot of this information.
I think we need a little more clarity on the boundaries. And again, this wouldn't be a very burdensome deposition. We're only asking for 3 hours, about 6 topics. For example, since we're on Mr. Wayman, the CMO, he was an employee of a German corporation that Smith & Nephew owned. I don't think that corporation was a parent company of Smith & Nephew Inc. And the question is, how much did this chief medical officer's role expand over distinct legal entities? We're not sure. So they can say, oh, well, he was the chief medical officer for Smith & Nephew, but that's a different question than saying he was the chief medical officer for Smith & Nephew Inc. during this time frame. It's sometimes a little ambiguous. For example, topic B, Mark Wall was the U.S. marketing director for, I believe, metal on metal hips for Smith & Nephew Inc. But for some reason, he was the director for Smith & Nephew Orthopedics Limited for at least a few years. We asked him about it, and my recollection is he wasn't quite sure why. We'd like an answer from Smith & Nephew Inc., his employer, on why he was involved with Smith & Nephew Orthopedics Limited. And then the last topic, topic F, and this really illustrates the ambiguity we have on these entities. Smith & Nephew had an advanced surgical devices division. That was not a legal entity, I think. That's what we want to ask. But we've seen multiple employees worldwide who are all part of the Advanced Surgical Devices Division, even though it's listed as it's sometimes called for Smith & Nephew Inc. But for example, there were UK employees who were part of the Advanced Surgical Devices Division. There were US employees, but they sometimes worked for other Smith & Nephew legal entities. That sort of information we need to tease out now, so that we have that evidence available in making the decision on, do we really need to sue PLC? Do we really need to sue Orthopedics Limited? Because we haven't had a chance to conduct specific tailored jurisdictional discovery, which I think is going to happen. But for Mr. and Mrs. Badali, they're entitled to find this out. And there is just no showing on the record of the benefit being outweighed by the burden or expense.
He is right. It doesn't sound like you presented any evidence on that. I mean, this is kind of my thought on this. This is not a ruling yet, but this is kind of where I'm leaning towards is give you the opportunity to take a short deposition. If it turns out that you're just covering old ground again, I may allow Mr. O'Quinn to request reimbursement of his attorney's fees and costs associated with that. If you're just going to repeat what you've done in other cases, I'd also encourage you to maybe enter into a stipulation. A lot of this stuff could be done by stipulation, I think, stipulating that the American entity is the correct entity and that there's not going to be a defense that somebody else was involved in developing or designing or things like that. Mr. O'Quinn, if you're not willing to do a stipulation like that, then it kind of says to me that maybe there is more to the situation.
Your Honor, we are willing to do it. And I think it can be done for some of these. I think the topic A is kind of the potential sticking point for a stipulation because it is pretty broad. The role, if any, in all these categories from 2006 to 2011. But for the others, I think we can get them answers, and if that'll take care of it, then we can put it to bed. B through F.
Another option is, and I don't know which would you prefer, Mr. O'Quinn, would be to allow him to do a deposition on written questions with maybe 20 questions, but that may take more time than the deposition itself.
It depends on the questions. Exactly, Your Honor. It could be a real needle in a haystack type thing. It might be easier just to get a witness up there, but I appreciate the court's input and sensitivity to, why do we need this? If we could adjourn the hearing and talk about a stipulation on B through F, maybe we can work it out. What
do you think?
Your Honor, we're happy to try. In worst case, we'll just come back to the court if we need more guidance.
So how do you want to leave it now? Do you guys want to kind of try to chat about everything and then come back to me on a future date? Do you want to go to a breakout room right now and then come back? What is your preference?
I'm happy to go to a breakout room right now if Mr. O'Quinn is available.
I am. That would be fine with me, Your Honor.
And who do I put in the breakout room exactly?
For the petitioners, just myself and Mr. Kip Petroff.
Okay.
And for the defense, myself and Mr. Brian Johnson.
Brian or Trent Johnson?
Brian Johnson.
Johnson Trent, Your Honor.
Johnson Trent is the firm. Yeah, sorry.
Oh, I'm sorry. Okay, so I think I have everybody. And Sean McCafferty's not on this case, I don't think. Okay, so I'm going to open a room for you guys to go into. Just come back whenever you are finished.
Thanks, Judge.
Okay, Brandon, I have a little project for both of you. I'll be right back, guys. Okay, can you guys hear me okay?
Yes, Your Honor.
All right, so let me see. All right, so what did you guys work out on the Dolly case?
So, Your Honor, what we're going to do, we're going to try a limited 3-hour deposition on those topics, and if we run over any old ground, they can come back and ask for fees.
Mr. Quinn?
Yes, Your Honor, we're going to try it that way. We also discussed trying to give us, to the extent they can, more specificity on number A. For example, during the break, we discussed some things related to the particular surgeon involved in this case. If they have things like that they really want to know, to the extent that they can provide those in advance, it would facilitate the deposition. But the basic core idea of 3 hours on topics A through F, if it turns out that, it was really just going over things they already knew or should have known, then we'll bring it back to you. If not, we're done.
Mhm.
Go ahead and prepare an order for me, Mr. Famonti, and then share that with your opposing counsel. Make sure that it's that you state on the order that this hearing was held at the beginning, instead of on this date, say that on November 8th, 2021, that this was heard. Share it with opposing counsel, try to get them to sign off on it. That's always makes it easier. And Mr. Johnson, looks like you had a question.
Your Honor, I did, and it's for Mr. O'Quinn, but it relates to your order. What is a reasonable time frame, David, for us to be able to get this done?
Well, we've already, as both sides, Your Honor, are pretty busy right now because we have a trial date in February. We have a bunch of motion hearings in December. So I would ask for until December 15. If we can do it sooner.
Is that in
great.
this case or another case?
I'm sorry, Your Honor.
Is the February trial setting in this case or another case?
It's in another case in Texas. I'm just saying that logistically, both sides are really busy. I'm really busy. We've got other corporate rep depositions to complete in November. And rather to be safe than sorry, if we could have till December 15, that should be enough.
What do you think?
No objection. We're okay with that.
Great. Anything else, guys?
No, Your Honor.
No, Your Honor.
Just get me an
Thank you.
order as soon as you can. Make sure you e-file and as well as email it to my court coordinator. And again, on the beginning, it needs to say on November 8th, 2021 is when the hearing was held.
Yes, Your Honor.
Thank you, Your Honor.
All right, guys. Thank you. Have a great day.
You too, sir.
Thank you. Okay, DC 2012084 Canterbury Co versus Thv Construction Llc.
Hey, good morning, Your Honor. Sean McCafferty on behalf of the plaintiff, Canterbury Co.
Okay, anyone here for the defendant? Mr. Hayes, are you here?
I don't see him yet. I know he's got the link because he sent me the link this morning.
There's a lot of people in the room. I don't know who they all are.
My associate Ryan Owen was going to handle this hearing as well, Your Honor. So I don't know if you can tell him in the room or not.
He is in the room. Why don't you call Mr. Hayes and just find out what's going on?
Sure,
You can put me on mute and I'll go to the next hearing.
will do. Thank you.
Anyone here on Preston versus Trinity Railway Express? Mark Scott is the plaintiff's attorney. Harold McKeever is defense attorney. Okay. United Laboratory. Let me deal with the rest. Anyone else here on the scheduling conference docket? Lester versus Moreno. DC 214965. United Laboratories versus Colonial Enterprises. Okay, strange. All right, we have a number of other attorneys here. What are you guys here for? Can you guys hear me?
Your Honor, I don't think they can hear you because My associate just emailed me and said he's stuck in the waiting room, and I'm
is he?
assuming.
Oh, oops. Okay. Never mind. Okay. Oops. It's hard to tell with the way this was set up. Okay.
Your Honor, Ryan Owen here on behalf of plaintiff in the Canterbury Cove case. I apologize. I was stuck outside the waiting room for a couple minutes there.
No, that's okay. That's my fault. So is anyone here, is the defense attorney here for Canterbury Co versus THB Construction? Oh, Mr. Hayes, we can't hear you.
Oh, yeah, come down.
Mr. Hayes, you're muted. You need to unmute. Okay.
There we go.
Great, perfect. All right. Rhonda, let's go on the record on cause number DC 2012084, Canterbury Co versus THB Construction LLC. Council, make your appearances.
Your Honor, Ryan Owen and Sean McCafferty here for plaintiff Canterbury Cove.
Scott Hayes for defendants THB and Travis Boney.
All right, let's proceed.
Yes, Your Honor. And as you're already aware, this is a construction case between Canterbury Cove and it's a real estate developer and THB, a general contractor. We have a bench trial coming up tomorrow. Now, in preparation for that trial, Canterbury Cove has moved to compel certain documents from THB. And this was not our first motion to compel, Your Honor. This is our third. We filed one earlier this year, another one back in August. The one in August resulted in an order from the court stating that THB was required to produce key documents, certain financial documents, by September 27th. And THB failed to do that. Canterbury Cove gave them an additional week to produce these documents. They did not do that either. They have turned over some financial information since November 5th. However, that information is far too general based on what this court ordered. Now, those documents, they relate to THB's financial position, balance sheets, income statements, but more specifically, financial reports generated by their accountant, which would show whether certain assets were ever commingled for Canterbury Cove with other projects. And Your Honor, they produced some documents last Friday just before this hearing, although, I believe it was a 2019 and 2020 tax return. They also provided some general, balance sheets and income statements, things like that, but nothing to the level that this court ordered to be produced in its September 20th order. And Your Honor, that's why we're moving for this third motion to compel. And we're seeking two things at this time, Your Honor. I think the motion probably asks for a little bit more. But specifically, we're asking for non-monetary sanctions in the form of a finding of fact regarding these financial documents that, THB did not segregate Canterbury Cove's, any income, the assets related to that project with other projects. And also, Your Honor, we're asking for monetary sanctions in the form of $2,500. And, I realize that those usually aren't given on the first go around, but again, Your Honor, we've had to file, two motions to compel before this. It seems like every time we ask for documents, defendant tends to drag their feet. So, Your Honor, for those reasons, we're asking for the non-monetary and monetary sanctions at this point, just before trial.
Hayes?
Sure, Your Honor. When we had the hearing previously, the argument for the need by the plaintiff was, did our company have the financial ability to complete this job? Our argument at that point was that, that's not part of the contract. That's not relevant. In any event, there was discussions about production of tax returns and financial statements of THB. And as an alternative, what the court talked about, if in fact the account was segregated for this particular job, then that could be provided. Then if not, then financial information. And based upon our review then, as there was not a segregation of necessarily the monies for this account, then we went ahead and just produced the tax returns for THB during the relevant provisions years. We also produced the financial statements of the company for 2019 and 21 was actually outside reviewed in 2019. So from the tax returns and financial documents produced, I think it was beyond, excuse me, the court's order. And again, initially the conversation was, we don't want to produce tax returns and financial statements, but as we looked into it, that's what we ended up doing, which would provide them the information necessary for their argument, albeit we contend irrelevant, that there was some financial ability on problems of our company not being able to perform. So,
Mr. Hayes, is it your position that you fully complied with the court's order?
as what we have provided by the tax returns and financial statements, that we believe we have complied, including the financial statements as to the company.
Your Honor, if I can briefly respond to that.
Yes.
The notion that THB has fully complied at this point, I strongly disagree with. I mean, they've both failed to comply from the timeliness perspective. We, just received these documents on Friday and, had a chance to take a look at them over the weekend. Again, the court ordered these documents to be produced on September 27th. And then the language of the court's order from September 20th indicates that, defendants should produce any documents necessary to show or to establish that the use of funds paid, if the funds were in a segregated account. Alternatively, if THB cannot do that, then, to show that the funds were in a general operating account, to show whether the funds were segregated or not. That was kind of the issue that we were working with here. THB has failed to produce documents that would show whether the Canterbury Co funds were in a separate account or not, and thus has not complied with the court's order.
I'm not sure I'm following that, but what I would suggest we do, we have trial tomorrow, right? How long is this case going to take to try?
Your Honor, we anticipate at least 2 days.
2 days?
I agree.
Okay. All right. My thought is let's go ahead and let's deal with this at trial. I mean, dealing with discovery issues the day before trials leave a little bit. And if it turns out there was information that should have been produced, it's a bench trial, you can bring it up at that time. If it's argue about all of that, then I just don't think it makes a whole lot of sense at this point. So let's go ahead and just deal with this tomorrow. So let me tell you what I need for the bench trial tomorrow. It's going to be that long. I need basically 3 documents from both sides, included in one binder. I'll go ahead and tell you where to send the binder unless you can get it to me by 4 o'clock today. So the first thing I need is exhibit lists for both sides. So I need in the binder both sides exhibit lists. I need the most recent pleadings from both sides, so from the plaintiff and the defendant. I guess I need 4 things. I need a proposed judgment from the plaintiff and the defendant. And then I need, if possible, this is, I know sometimes difficult, but if possible, proposed findings of fact, conclusions of law. And would this be something you guys could get to me before 4 o'clock today?
I think so, Your Honor. We've already been working on. We anticipated getting you a joint notebook.
Yes, and we've got the joint notebook about ready, which plaintiff has taken the lead on. But yeah, we can do the others as well.
So either this needs to be delivered to the court at by 4 o'clock today. If it can't get to the court by 4 o'clock, then I'm going to go ahead. I'm going to turn YouTube off. I'm going to take you into a breakout room, and I'll give you my